and guest alone, and not those of Vic Canellis Media Group, its parent, affiliates, or stations. VCMG Live is not responsible for any content, information, or opinions expressed. User bears full responsibility for their reliance on such content, information, or opinions.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Hey, good evening. This will be an hour-long show from 6 to 7 p.m. This is the Ask the Expert show. We're with you every Thursday night from 6 to 7 for your drive time. And this is our new show, but an old show. This is our last Thursday Kay Bender Rimbaum show. They've been doing the show the first Thursday of the month for the last 5 years, and because we got so many emails from listeners saying, how come you don't have them on more often? Well, we made a change. We were able to make a change, and now they are with us the first Thursday and the last Thursday of each month talking about community association law. Tonight we have another attorney from the office. She is Allison L. Hertz. She's the board certified in condominium and plan development law by the state of Florida. If you'd like to call in, if you have a question for attorney Allison Hertz, the phone number here is 888-565-1470. Call in. We'll be here for the next hour. This is a live show. This is not a tape show. 888-565-1470. Let me introduce you to our expert, Allison L. Hertz. Good evening, Allison.
Good evening. Good to be here. Thank you for having me.
Listen, thank you for taking the time out of your day. I know you guys are always busy over there at Kay Bender Rimbaum. Allison, tell everybody about your background and what you do at Kay Bender Rimbaum.
Of course, I am a condominium and homeowners association attorney. I'm actually in the Palm Beach Gardens office of Kay Bender Rimbaum. We specialize in all things community association law, and I help my clients, mainly condo, co-op, and homeowners associations, with their day-to-day problems and any significant issues that arise in the community. I would also like to note I'm the incoming co-chair of the Florida Bar Real Property and Probate Condo Committee. So I am very involved in all things condo once again, and particularly a lot of the legislation that we see year to year. Definitely have my hands in some of that.
From what I understand, there's a lot of legislation going on, new laws that are coming out or are out, especially with the, what happened with the condo. And now there's new rules now, especially if you're over 3 stories high condo.
Yes, that's correct. That has been the talk of the town now, and I'm sure everybody's read about it in the papers and heard about it on our shows and our educational programs. That, of course, coming out of the tragedy of Champlain Towers South, we expected to see some new legislation, regulations, and we did not see anything during our regular legislative session this year. But all of a sudden, in late May, I believe, we did receive Senate Bill 4D, which has significant new requirements for condominiums and co-op associations, including building inspection reports and structural integrity reserve study requirements. So those are the primary areas that are addressed within that new law. again, for condos and co-ops. And it's a pretty big deal. I've been doing this a long time now, and this is probably the most significant change of the statute that I've seen during my time, or that I think that there has been, of course, deservingly because of that tragedy. And we can get into those requirements in more detail. I'm sure. I think a lot of people have questions. It's
Yes.
new.
Are you okay with how the law reads now?
Well, we have some technical issues with the law. It's 88 pages. So in 88 pages, you can get some tricky issues, and I think there could be some more clarity added to this law, hopefully. I'm hoping to get forward a task force effort, at least with the Florida Bar's Condo Committee, in terms of possible technical amendments. But frankly, this is what it is today. And I don't like to speculate as to, what it might be or what the
Right.
changes might be, because I just don't know. And the requirements in this new package are very serious. And if you don't comply with them, there are consequences.
Right.
So I could expect some possible technical changes because I think it could be a little bit more clear, but it is what it is for now.
Well, we have a caller. Let's go to our first caller, Marla in Boca Raton. Good evening, Marla.
Hi, good evening. I was calling to ask regarding roofing insurance. We had a roofing insurance claim that's still ongoing, and the HOA couldn't wait any longer to settle the claim, so we assessed all the homeowners to replace the roof. Now, down the line, if we actually get some funding from the insurance claim, what would be the different options to reimburse homeowners, or what are you required to do with those insurance proceeds? And then if there are homeowners that have left and sold, would you be required to disperse any funds to them, or would that go into a general pot? Are there any set,
Understood.
For Florida law?
I understand the question. I think I do, in that you're going to potentially have these surplus monies at the end of the day after everybody's already paid these special assessments. And typically speaking, and particularly in a condo, these type of funds are going to usually be considered as a special assessment surplus, and the law would allow the board to either refund the current owners at the time the surplus arose, or give a credit to everybody's account in terms of whatever proceeds were obtained at the end of the day. But typically, the former owner who might have paid the special assessment, that owner is not going to receive these monies. And that kind of issue a lot of times needs to be worked out between a seller and a buyer at the time of the transaction, to say that in the event monies are obtained in the future, maybe the new owner has to pay back the prior owner. But that's typically the way it is in a condo, particularly. A homeowners association, it could be a little different pursuant to your documents. I always say for a HOA community, a lot of things are a document-specific issue. I hope that answers your question.
Yes, thank you.
You're welcome.
Thanks, Marla. We have a line open at 888-565-1470. What we do with this show is we ask you to text questions in, email questions in during the month, and then we use those questions for the show. Or you can call us right now at 888-565-1470. If you're a board member, management company, or you live in a condo or HOA and you have a question, this is the time to call. We're here tonight with Allison Hertz. She's a board certified. Like a lot of the attorneys with K. Bender are board certified, and that is a big deal.
Yes, it is a big deal. There's only about 120 of us condo and plan development certified attorneys, and we do have quite a number of them at KBR, myself included. I had to
So,
take an extra test for that
yes,
credential. So,
you,
I'm going to talk about it.
you should be very proud of it too, because you're right. There aren't very many attorneys in the state of Florida that are
Yep.
certified. I'm gonna take Sam's text first. Sam's, a lot of our texts are out of your area, Palm Beach office. Sam out of Boca Raton wants to know, when buying a condo, should I first ask if their reserves are fully funded?
That is a very important question right now as we sit here today. And I can't really think of anything important enough than to inquire about that specific issue. You want to ask the seller for the association's most recent financial report, a copy of the budget, copy of maybe the delinquency rate. A lot of buyers get so hopped up on, the pet restriction and the vehicle restriction and what my shutters look like and the color of my exterior door, that they don't think about the financial state of the association, which is critical in terms of community association ownership because you owe a share of the pot. And now with the new building inspection reserve study and the requirement that certain associations keep reserves at fully funded, or certain reserves at essentially fully funded levels beginning in 2025, you could be buying into a community that you believe is in good shape, and then all of a sudden, when we get to 2025 with the new reserve law, your budget is potentially going to triple, quadruple, even greater. So it's highly critical that you ask those questions. It's difficult though. The market is hot. If you don't make an offer immediately, you might lose out on your dream condo. Typically, you'll have some type of cancellation in there, and you got to work that out. But it is critical. Yes, it's highly important.
And it's funny because our next question is from Steve in Wellington. Wants to know, is it true that all Florida counties must adhere to all these new laws?
That is true. There is no exception as per county to some of these requirements, but the building inspection requirement really only relates to condos and co-ops 3 stories or more. And there are certain exceptions to that. The timing of it is dependent on when the certificate of occupancy was issued for your particular building. And this is a per building issue, right? This is not per when your corporation was formed. This is a per building issue dependent on your certificate of occupancy. As to the structural integrity reserve study, that once again applies to every single condo in the state, no matter what county you're in. There are other requirements. County is not part of this. There is a certain term or stipulation of this new statute that if you're within 3 miles of a coast, you might have to perform the building inspection report more quickly than if you are not. So that somewhat relates to the county issue, I suppose. That's the closest I could get.
We are going to go to our first break. Again, if you have a question for Allison, she's with K. Bender Rimbaum. If you have a question, whether it's an HOA or condo association question, give us a call here at 888-565-1470. There's no such thing as a dumb question. If there were, I've probably asked them all. We're going to go to break. Allison, give them the number. Well, I'll give it to you. It's 800-974-0680. If you'd like to call their office again, it's 800-974-0680, and their website is www.kbrlegal.com. There is a world of information on it. We're going to go to break. When we come back, we have more with Allison Hertz, K. Bender Rimbaum. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we are back. This Ask the Expert show. This is our 7th year of airing here on 1470 AM, 96.9 FM, 95.3 FM, or you can listen to the show on iHeartRadio by going to www.wwnnradio. This is the last Thursday of the month. That means K. Bender Rembaum. If you have a question, whether you're a board member, you are a management company, if you live in a condo or an HOA and you have a question from board certified, see, I'm going to put that in there because I know how special it is. Board certified, Allison Hertz. Our phone number here again is 888-565-1470. And we also promote that you can text your questions in. We know a lot of people are driving this time of night coming home from work. So we'll be reading text over here and emails we get. Our next one for Allison is from Kimberly in Fort Lauderdale. She says, we are a small condo. Our first story, I think this is a great question, but I mean, what do I know? Their first story of their condo is storage. So with 2 stories on top of the storage unit, is that considered a 3-story building?
I think that would be considered a 3-story building. Unfortunately, we don't have any definition of what a story is in this statute, and it wasn't tied to some other definition in some other portion of the building code or some other portion of the statute. So I think, you have to just give it its plain meaning, and that whether it's a storage area, a building on stilts with garages underneath, I believe that probably would be considered a story until we know otherwise. There's also nothing about, whether it's a habitable story or not. There's a very narrow exception to very small condos and co-ops of 1, 2, or 3 families only. So I would suppose up to 3 units. If it's that small, there could be a chance where you don't have to comply with at least the building inspection portion of this. But until we get more clarity, I would say yes, that probably would be.
Yeah, there's a lot of condos that have the garage is actually the very first floor, and then the second
Correct.
floor is, so I guess, I heard something, Allison, I don't know if it's true or not. I heard that the legislation didn't really do anything, and they got so many complaints. Maybe I'm totally wrong on this, but I heard they got a lot of complaints and they had to come up with some kind of legislation. Is that true or not?
Well, there were different bills bouncing around during regular session. There were a number of them. There were probably 5 or 6 different versions of laws that looked just very similar to this, but it was apparently very difficult for everyone to agree on the specific requirements. whether it be the 3-story issue. Some people would have preferred this to say more than 3 stories, which is considered a threshold building. So there were a number of issues that there were apparently disagreements on, but I believe that both that, due to the importance of the issue, that when it came down to it, both the Senate and the House felt like they had to act, and they called this quickly out. And, once again, it's not that different than some of the other ones that had been floating around. So it wasn't a complete shock, no.
Big difference between condo and HOA with the new legislation?
Well, this does not apply to homeowners associations.
Okay.
So homeowners associations are not subject to these particular laws expressly, whether we go to that or not. Maybe we will. There are some 3-story townhouses, and I could see that being similarly looked at, but not as of now, no.
Well, this has got to be Robert K's cousin that wrote this. Pepper in Palm Beach said, I listen to your show every month. I am the president of a condo association. I'm so glad you added a second hour, which I wrote the station thanking them. It's got to be Robert or Michael's cousin who wrote that. But they want to know, they want to know, this might be kind of a broad question. Can you explain these new condo statutes?
Well, we went through the new statutes quite briefly at the beginning. We have our building inspection requirement that by December 31 of the year in which a building reaches 30 years of age, measured from the certificate of occupancy, they need to run through this building inspection requirement. That could be bumped down to 25 years if 3 miles from the coast. And if your certificate of occupancy was before July 1, 1992, which is of many of our buildings around here, at least in Palm Beach County, you must deal with this by December 31 of 2024. So there's different triggers based on the different age of your building. But the fact is, as to the building inspection report, it's on the local jurisdiction, the local building department of the municipality, whoever's dealing with that at the town where you live, the village, the city. They are required to send you a notice of of the need to do this in building inspection, and then you have 180 days from the date of receipt to get that completed. There's 2 different phases. There's just the visual inspection phase. That's where a licensed engineer or architect goes out and it looks at your building and determines if there's substantial deterioration. If it doesn't see anything, you're good. You file your report. You keep it with the association's official records. But if you do have a report of substantial deterioration, you will have to deal with that by making the necessary repairs within, I believe it's 365 days. You have quite a while to get that done.
Okay. Let's go to the phones.
Yeah.
Let's go to John in Indian Shores. Good evening, John. John, are you there?
Yes, I am.
Okay. Do you have a question for Allison?
Yes, I'm the president of a condo association, and one of the directors resigned. Can the board just choose a temporary director for the remainder of their term? I have 2 candidates, or do I have to go to a full election for midterm?
Okay, the answer to that question is actually pretty clearly addressed in the Florida Condominium Act. For once, yay, we have a pretty clear answer. In that, unless your bylaws provide otherwise, the remaining board members are permitted to appoint the replacement, and the replacement will serve out the balance of the term where the other director just vacated. There are some unique bylaws which provide for some other procedure or require you to have an election, but it's really not that typical. I did just have an issue similar to this where there was a vacancy And rather than have the board select, they just put it out to a vote anyway because they were having a hard time determining who would be the replacement. A lot of the time you get into a situation where you have a 5-member board and it's like a 2-2 split. So you can't decide who is going to be that 5th member. And in such case, it might be, a good thing to do to get out and notice. Also, you might just, if you have people in mind, that's great. If they're willing to serve, if nobody is willing to serve or you don't really know, you can always put out a post, say we're looking for somebody, and seek people who want to volunteer, although you would not be required to actually accept those volunteers.
Okay,
Any
because
follow-up
we did
there?
put out a post.
Yeah.
We did put out a post. So, okay, so we can choose one of the 2 candidates to fill the board for the rest of the year. And then elections, whoever wants to vote then will be voted in.
Well, once again, it's unless provided otherwise in your bylaws. So that's the default
there's nothing
answer.
in the bylaws.
Yeah. Okay.
Yep.
Sounds like you're pretty
Yeah.
good there.
Okay.
Thank you,
Just wanted
John.
to check on that. Yep, thank you.
Let's go to Jack, another Palm Beach person in Boynton. Hi, Jack.
Hey there, good evening.
Good evening.
Allison, congratulations. I heard you mention your naming as the co-chair of that committee with the Florida Bar. That's awesome. With that in mind, when you meet with the committee, was there any discussion about whether insurance pricing could possibly level off once buildings begin to adhere to the new regulations, however they end up being tweaked going down the road? So do you think, is it possible insurance rates could be leveled off once the new laws are in place?
I mean, I think that will help long term, but frankly, I believe the increases are more to do with storms, right? Those are out of our control, and just inflation in general. The number of claims these guys have to pay out per year. I think in a long-term situation, if these buildings are rehabbed in the future, and you might be able to get discounts on your insurance in terms of, storm protection, and your roof is now better, new. So that's really all I can speak to on that point.
Yeah, I kind of figured. I was just curious if any discussion of that sort was thought of. Thanks so much, and again, congratulations. Great job.
Thank you very much. Thank you.
Thanks, Jack. We have a line open right now if you'd like to speak to Allison. 888-565-1470. That's 888-565-1470. We're going to go back to our text. Ben in Pembroke Pines, he wants to know, their building is 35 years old, and we're a condo conversion from back in 2003. Do we need an inspection due to the age of the building?
This is all dependent on when I would think the most recent certificate of occupancy was issued. That's an interesting question, which is really like a twist on all of this and a much more unique set of facts than we've dealt with in terms of when this was rolled out a couple weeks ago. But I think you would likely be dealing with a trigger date based on the most recent certificate of occupancy, which would be during the conversion, I would think. But again, that's a more detailed question. We'd have to really research that and figure it out a little bit more.
We just got a text in from a listener, and because he said please, I'm going to ask Vinny's question right now. Allison, do you think there is going to be enough inspectors and engineers to handle all these condos across the state?
Well, as to the building inspection and reserve study requirements, as you've noted and intimated, that these must be handled by licensed engineers or architects, and the reserve issue is interesting because we don't typically have that requirement for people who perform reserve studies. So a lot of the people who work in the reserve analyst field are, having to deal with that. And I think the industry will probably adjust and that they will be able to provide these services. I think it's going to be difficult in the very near future because everyone is really still sorting this out, sorting their business models out. But I've heard from a number of engineers who are ready to do this work and want to do this work. This could be one of those opportunities where we see this as some sort of new cottage industry where people are diverting from their current specialty field to join up with other individuals and professionals to really ramp up these kind of ventures with different industry people. So I think we have to see the industry sort of adjust. And I think I can't predict the future here, but I would suspect people will want to make profit off of this, just to say it like it is, and that they will adjust to it and try to provide the services.
If you'd like to call here and have a question for Allison, the phone number here is 888-565-1470. Allison, this next question, God, we got so many listeners asking the same question, really. This is an HOA. They want to know, can they change a tennis court to a pickleball court without owners voting?
Well, this is a completely different answer from a condo association to a homeowners association.
Okay.
So I hope this person who submitted the question is truly in a homeowners association, because sometimes, they throw the name around,
Right.
but it's really a condo. So in a condo, I'm sure you've heard a million times if you've been doing this show for 7 years, and everybody out there listening has heard about material alterations to the common elements and how they might need an owner approval because the Condo Act provides for that. Well, there is no equivalent law in the Homeowners Association Act. There is no material alteration and vote of the membership. So this is what I said would be one of those governing document specific issues where you really have to take a look at your governing documents to see what they say about the authority of the board without lot owner approval to make improvements and alterations to the community. I think a lot of documents give the board broad authority, and if they are silent, I think the board has a defensible position to do that without owner approval, pending some very specific item that's addressed in the documents. For instance, you shall always have a pickleball court, and you cannot remove, or you shall always have a tennis court and not convert it. So for an HOA, there's a good chance that your board might be able to do that without owner approval. You really got to check your documents and get with your lawyer about that to be sure. It's probably something you want to look at in advance and not after the fact.
Okay. If you have a question for Allison, the number here is 888-565-1470. We are talking about community association law. If you are a board member, if you are with a management company, you're a resident in an HOA or condo association, and you have a question for Allison, again, it's 888-565-1470. Here is one. Oh, this is interesting. Bill from Boynton wants to know, can a board member tell owners about the new laws, or is that considered practicing law without a license? Must any info come from the condo's attorney? You're smiling real big.
Well, I think the person who submitted this question, Bill, is that who
Yes, Bill.
was smart and to ask this, because you don't want to overstep your boundaries in any board action here. And if I were on a board, I'd be sort of worried about the same thing from time to time. But I don't think there's anything wrong with sharing your knowledge. I think your membership would appreciate it. Your board members, your fellow board members would appreciate it. And there are many ways that you can share this information without putting your own legal spin on it. You can forward them our blog. Jeff Rembaum just issued Rembaum's Roundup with a summary of all of these laws. So it's right there to forward on. I know there's been other articles in the paper and other blogs. So I think you have a way to deal with this without even really trying to analyze it yourself. If you're trying to analyze the law yourself and come up with your own theories on it and put those into motion, that might be a little bit above what you want to do. But I think there's many opportunities to get around that. And even our firm has a lot of resources that you are able to share and that would help you out and help your membership get prepared for some of these changes. Because if you don't communicate, it's like a double-edged sword for this person. If you don't tell everybody about it, they'll ask you at the next annual meeting, well, why didn't you tell us about anything? You knew and you didn't share. You're not being transparent, which we hear all the time, right? So I think it would be helpful to share the information and get the advice from third-party sources if you're worried about it whatsoever.
We were going to change the subject up for a little bit, and I totally understand this question that we have. It's in regards to a next-door neighbor who is a chain smoker on their balcony, and they're saying they cannot enjoy their balcony because of the smoker. What can we do? Is there some type of nuisance clause?
Yes, this is an issue we face from time to time at the law firm. I've seen these disputes throughout my legal career. A couple of things to mention here. Yes, there usually is a nuisance provision in a declaration. It says something like you can't unreasonably impair the enjoyment of somebody else's unit by virtue of your actions. So you can't unreasonably disturb. And here it kind of becomes a little bit subjective as to what is excessive, what is unreasonable. There's an amount, unless there's a smoking rule, there is an amount of smoke that is going to be okay. It only becomes a nuisance when it gets into it being excessive. Of course, you can ask the association to intervene, do an investigation, and follow up with some sort of demand in terms of asking this person to, lessen the amount of smoke or frequency that they're going out there. But also, owners have the right to enforce covenants, meaning provisions of the declaration, against each other. So if your association is not willing to intervene, they tell you, listen, this is a neighbor to neighbor dispute, because sometimes that's what I tell people. And it is that you as a unit owner have the right to go directly against the adjacent owner for violating the nuisance provision or whatever provision you're trying to enforce. It could be maybe there is a no smoking provision. And I would suggest that you ask your association to think about adopting a no smoking on the balcony provision or address it in some sort of rule or declaration amendment manner, which becomes easier to enforce than trying to prove that something is excessive or unreasonable.
We just got a text from a listener wanting to know, what can I do about handicap parking? I'm in a condo and all handicap parking is always taken up and I never have a parking space. What can I do?
This is a tough one. So I imagine this is a condo that's probably from a while back, and they were allowed to construct the property with very few handicap spaces, or there's just many handicapped people apparently at this condo. So there could be a possibility where you aren't going to be able to get a dedicated space. If there's just not that many spaces, you can ask the association to have you swap spaces with somebody else who's closer to the entrance. But depending on the provisions of your declaration and whether that person is agreeable, that might not work out as if they're assigned parking. If it's just general parking that the board assigns sort of in its purview, you can ask for a spot that's closer to the entrance. But it really depends on a couple factors and whether there are dedicated or non-dedicated spaces, and what the declaration authorizes the board to do in this circumstance. Sometimes the boards want to help, but their hands are really tied because all of the spaces are dedicated and assigned, and they don't have the authority to frankly remove that person from their dedicated space without their consent to at least temporarily allow you to go in there. So I can see that being a difficult situation.
You know what? We've been doing this show going on 5 years now. And when we first started doing the show, I bet you every other question was about support animals. And even the different Ask the Lawyer seminars that you do, there were so many people with pet support. We don't have one. I mean, we don't, in fact, we rarely hear about anything having to do with pet support anymore. Do you find that to be true in your?
Well, I think people are sort of desensitized to the fact that a lot of the time these animals are going to be allowed. It's very difficult to object to them. If an applicant makes a facially valid application and it hits the points, they're disabled, they have a disability related need for the animal, there's very little that the association can really do without subjecting it to claims of discrimination. And yeah, you're right. We've seen that for so many years. I think people finally understand, and especially board members who've served for a long time, that, this is the way it is until the law is changed. This is the way that it's going to be. The Florida law was changed a couple of years ago, and here in Florida, not the federal law, to sort of put some more parameters in place as to these requests and indicate that it could be a certain misdemeanor if you're found to have fraudulently attempted to obtain an animal related to some fraudulent disability. I've yet to hear about anybody being charged with that misdemeanor, right? So I'm curious to know if that's ever even happened. But, I guess it's one of those things that they put in as to try to stop people from using the fraudulent requests. And it just is sad for the people who really have real requests that they have to hear all the time about all these fraudulent requests, because there really are truly people who are entitled to these. So it's difficult, but I think people are pretty desensitized to it, at least from my perspective.
Allison, we got to take our last break. We're here. This is the last Thursday of the month. This is the might as well just call it the K. Bender Rimbaum Hour. We're talking to board certified Allison Hertz, and we're going to go. This is our last break. When we come back, we've got more. If you'd like to give us a call, we still have some time. 888-565-1470. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we're back. I want to give you the phone number at K. Bender Rimbaum if you'd like to give them a call. It's 800-974-0680. That's 800-974-0680. Or you can go to their website, www.kbrlegal.com. Great information. There's more information on this website. And a certain person that you know, Allison, has got his own roundup.
Yes,
Jeff
Rembaum has
Yes.
his newsletter, which is quite comprehensive
Yes.
and really well done. You'll find all of the archives on our website. It's a great resource. You could do your own little digging before you call for legal advice. And it probably is a good time for me to remind that we have a number of educational courses upcoming. We do those all the time through the firm. We have several each month. I frequently do these courses. We put on these seminars. July 11th, we have a seminar Zoom with CAI's Legislative Alliance. It's an update, and I'm sure they'll be talking in much more great detail about the building inspection and reserve structural integrity reserve study requirements. That's a mouthful, right? July 20th, we have another webinar with Lisa McGill. She's great. This will be on the screening process, how to develop procedures and train your screening committee. We also talk about authority to screen transfers. I mean, that's a common area we see where board members or even managers tend to think there's some inherent authority to screen and approve leases and sales, and that's not necessarily the truth. Lisa can give you all of the updates there. And then lastly, for July, we have a Homeowners Association board member certification course on July 28th. That's with Emily Gannon. She's out of our Pompano Beach office, also a great attorney. And you should definitely look at our website and sign up to view these courses on Zoom. They're very helpful.
Allison, let's go to Carol in Fort Lauderdale. Good evening, Carol.
Oh, hi. How are you?
Doing well.
Hi.
I'm calling for the first time in. I live in a co-op, and my condo board, they asked for special assessment for the painting the building, $2,800, and that was back in March. And now they want to fix something else, and some of us people don't have all the money. And the point is, I have to make payments. They cannot evict me or foreclose on me as long as I make payments. Is that correct?
Well, you definitely want to keep up with payments. You mentioned that there were 2 recent special assessments that have been difficult to pay. And I'm not sure if they were installment assessments, meaning that you had multiple payments, or they were due in one lump sum. If they're due in one lump sum and you don't pay, then that gives the association the right to start with the collections procedure. The first step in that procedure is to send you a 30-day late letter setting forth the amounts due. And in such case, if you receive that, or even before you receive it, if you know that you're not going to pay, there could be an opportunity for the association to agree to some kind of payment plan with you, that maybe they'll say, you know what, if you sign a document where you say that you'll pay X dollars a month, that they will forbear, that they won't move forward with collections as long as you continue to meet that payment plan. But I would not just think that you can make payments like you would do on maybe like a credit card, minimum payments. That doesn't apply here. So you're going to get wrapped up into owing additional amounts, legal fees, interest, late fees, and these can get substantial. So you can talk to your board about whether there's some opportunity for them to make some sort of agreement with you, but not paying and making up your own sort of minimum payments is not going to really cut it in the eye of condo co-op law because of the significant remedies that you did mention with the lien foreclosure. So that, they would be able to proceed with that if you remain delinquent in some fashion.
This.
Any follow-up there?
Yeah, that's 20. We had 2,800. I had to pay 2,800. They decided mid-February, and they wanted the money on the 1st. And then they wanted a payment plan for 3 months, 900. I paid it out of my savings, but now they're coming up and fixing something else. And that's supposed to be priority. But I was wondering, I asked the board, can we not have a inspector and see what needs to be done first? And that prioritize it. Instead of them making because
it's very difficult for the boards these days to administer the property, and particularly these buildings that haven't had a lot of deferred maintenance done, especially with the tragedy with Surfside. If there is an item that needs maintenance, there's necessary maintenance that must be done, their hands are kind of tied in terms of trying to evaluate whether to move on it now or whether to wait. There are a lot of claims that the boards face when they don't move forward. So the fact is that there is maintenance that has to be done, and the owners will have to pay for it. If the item is a necessary item, roof, waterproofing, the board is going to have to make those assessments and try to act as fairly as possible. I don't think anyone on a board really wants to force people out of their own community, but it does have to pay for these expenses, and the maintenance must be performed. So there's other financial tools that can be used for large scale projects. Maybe the association goes out and borrows money so that the payments aren't due as quickly and you can spread them out over more of a length of time. But for the smaller and less expensive projects, they probably aren't going to do that.
Okay, thank you, Carol. Well, the hour goes by really fast, as you can see, but we got a lot of good questions in, and you did such a great job tonight, Allison.
Thank you.
Allison will be on next Thursday. We'll have Robert Kay with us, and we will have more of Ask the Experts then. Again, the phone number at K. Bender Rimbaum is 800-974-0680. That's 800-974-0680. And again, Allison, what a great job you did tonight. Thank you so much, and I hope we have you back again.
Oh, yeah, I'll be back.
Thanks, Allison.
Can't get rid of me that quick.
And we will see you all next Thursday with more Ask the Experts. Have a happy 4th of July. We'll see you soon.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.
The opinions expressed